Good morning, friends. My today topic is family settlement. Before going into detail on this topic, I would like to share with you what is family settlement. A family arrangement is an agreement between members of the same family intended to be generally and reasonably for the benefit of the family, either by compromising doubtful or disputed rights or by preserving the family property or the peace and security of the family by avoiding litigation or by saving its honor. The agreement may be implied from a long course of dealing, but it is more usual to embody or to effectuate the agreement in a deed to which the term family agreement is applied. Now I will share few of the examples of division of property which is generally accepted as family arrangement. An agreement for the division of family property by way of compromise of a family quarrel or litigation about a disputed or lost will, or even to prevent family friction, where there is no question as to the devolution of the property, nor any disputed right, there being some consideration for the arrangement other than love and affection, or any arrangement as to division of property, where the construction of a bill or other instrument under which the party's claim is doubtful. Secondly, an agreement dividing up family property, though entered into under a misapprehension of the legal rights of the parties, provided the misapprehension is not induced by any party to the agreement, even where the misapprehension existed has been established by subsequent legal deceit. Now, third one is an agreement between members of the family to divide equally whatsoever they obtain under the will of the ancestor. Fourth one is an agreement between co-heiresses dividing the property between them. Fifth one, an agreement between the heir at law and a person supposed to be entitled under a lost will, dividing the property between themselves and other members of the family. Sixth one is an agreement dividing the family property between the members of the family, where some of the members had a title independently of the will of their father, who purported to dispose of the whole among his sons and daughters. Now, coming to principles governing family arrangements. Family arrangements are governed by principles which are not applicable to dealing with between strangers. When deciding the rights of the parties under a family arrangement or a claim to upset such arrangement, the court considers what, in the broadest view of the matter, is most in the interest of family and has regard to considerations which in dealing with transactions between persons not a member of the same family would not be taken into account. Now, coming to considerations favoring family arrangements, considerations which will lead a court to suppose a family arrangement are that as a result of family arrangements, disputes are avoided in the family, the honor of the family is safeguarded, or various obligations morally binding on a family are provided for, or family property is continued in the family. Now, coming to the parties in general in family arrangements, any member of a family may be parties to a family arrangement. Thus, agreements between husband and wife, parent and child, legitimate or illegitimate, uncle and nephew or nieces, co-heiresses and brothers have all been supported as family arrangement. Now, the next question is, how far consideration is required? Since the consideration for a family arrangement is partly value and partly love and affection, the pecuniary worth of the consideration is not regarded too closely. The court will not, as a general rule, inquire into the adequacy of the consideration. But there is an equity to set aside a family arrangement where the inadequacy of the consideration is so gross as to lead to the conclusion that the party either did not understand what he was about or was the victim of some imposition. Now, coming to what is the basis for validity of family settlement? We will now have a look at the concept of family settlement and the basis on which the same is recognized as valid and binding between the parties. It is often found that between members of the family claims and counterclaims are made against one another in respect of property held by the members of the family and claims of ownership maintenance are conversed with a view to avoid protracted litigation and exposure to public gaze of private family disputes. Very often, the family members try to bring about an amicable settlement of the family differences by invoking the assistance of well-wishers of the family and arrive at a settlement of their mutual rights and obligations. Such family settlements may result in transfer of property or recognition of right of some members of the family in various properties in dispute or may create limited right in respect of such properties in favor of various members of the family. The word family is not to be interpreted in a narrow sense of members of Hindu joint family as defined in Hindu law, but it will include wide range of persons who belong to one family in its comprehensive sense. The basis on which such family settlements are held as valid and binding between all parties is the mutual consideration which flows between parties while putting an end to claims and counterclaims between them. It has been held under the law of contract that it is lawful consideration for a party when he gives up his claim to any property in return for any payment or transfer of property made to him or any obligation undertaken by the party. Existence of the right in the property is not necessary in order to make the family settlement valid and binding for a valuable consideration. The existence of dispute or a threatened dispute between the members of the family is considered to be a precondition for a valid family settlement. And such disputes and the consequent giving up of claims and counterclaims between the various members of the family constitutes good and valid consideration between the parties for enforcement of rights and obligations created by such a family settlement. The family settlement, therefore, is not founded on existing rights or liabilities, but rather on existing claims and disputes between the parties, which are amicably resolved. Notices may be given by contending parties, even suits may be filed, matters may be referred to the arbitration, and award may work out as family settlement. Now, sometimes the question arises whether family settlement is a transfer. The question has often arisen before the courts as to whether such family settlements result in transfer of property from one person to another and whether such a transfer can be said to be without consideration. A reference may be usefully made to the decision of the Supreme Court in the case of Ramchandar, Ramcharandas versus Girja Nandini Devi, AIR 1966, SC 323. The Supreme Court, Honorable Supreme Court has therein observed that such family settlements between the members of the family bona fide to put an end to the dispute amongst themselves is not a transfer. It is also not a creation of an interest. In a family settlement, each party takes a share in the property by virtue of independent title, which is admitted to that extent by the other parties. Every party who takes benefit under it need not necessarily be shown to have under the law claim to share in property. All that is necessary to show is that the parties are related to each other in some way and have a possible claim to the property or a claim or even a semblance of claim on some other grounds as a affection. In the same case, the above-mentioned case, the Supreme Court has given the reason for recognizing such family settlements as valid. It has observed courts give effect to family settlement upon the broad and general ground that its objective is to settle existing or future disputes regarding the property amongst members of the family. The word family in the context is not to be understood in a narrow sense of being a claim to share in the property in dispute. Now, coming to further question, is a writing necessary for affecting family settlement? Observations in the case of Take Bahadur versus Devi Singh, AIR 1966, Supreme Court 292, also indicate that such family arrangements can be arrived at orally. Its terms may be recorded in writing as memorandum of what had been agreed upon. The memorandum need not be prepared for the purpose of being used as a document on which future title of the parties is to be founded. It is generally prepared as a record of what has been agreed upon in order that there are no hazy notions about it in future. It is only when the family arrangement is reduced to writing with the purpose of using that writing as proof of what they had arranged and where the arrangement is brought about by the document as such that the document requires registration. Because it is then that it would amount to document of title declaring declaring for future what rights and in what properties the party possess. What a document which is no more than a memorandum of what has been agreed to between parties does not require compulsory registration under Section 17 of the Registration Act. Similar observations regarding registration can be found in AIR 1966 Supreme Court 1836 Pullia versus Narasimha. The nature of family settlement and allied questions whether such settlements amount to transfer for purposes of capital gain or registration have been dealt with by several decisions of the Supreme Court and also by some high courts, which explain what is family settlement and why it does not amount to transfer and why the memorandum of family settlement does not require registration. So I am listing a few of them. First one is CGT versus DN 2013, volume 1 to 9, Taxman 822, Madras. Second one is CIT versus AL Ramanathan of 2000, volume 245, ITR 294. That is also Madras. Then Lakshmi versus Chakra Bhati, AIR 1999, SC 3363, SK Satar, SK Mohammed Chaudhary versus Mudappa Bukti 1996, SCC 373, Bakhtawar Singh versus Gurdev Singh and another 1996, SCC 370, Tarkanath versus Sushil Chandradev 1996, SCC 697. There are so many others. Roshan Singh versus Jaila Singh, AIR 1988, SC 881. Kale versus Deputy Director of Consolidation, AIR 1976, SC 807. Shambhu Prasad Singh versus Phool Kumari, AIR 1971, SC 1337. Now, again, the question will arise, family settlement and tax planning. Now, let us examine the scope of tax planning in connection with family settlements. As already seen above, what is really a family settlement and what is the nature of transaction brought about as a result of such family settlement. The utility of the instrument of the family settlement for tax planning may be examined in the context of joint family property and individual property. Now, firstly, joint family property. As far as joint family properties are concerned, the most commonly used media of tax planning is affecting complete or total partition. Honorable Supreme Court has now held in case of Apurva Shantilal Shah versus Commissioner of Income Tax 1983, Volume 414, ITR 558, Supreme Court, that the father can affect partial partition even if he has minor sons in exercise of his powers as patria potestas. He is not disabled to look into interests of his minor son. It has also been held that even unequal partition can be effected by the father or with consent of all the capersoners and only the concerned parties aggrieved by it can challenge the same. Till then, it is valid. Now, another decision, CET versus Kantilal, 3 Kamalnal, 105 ITR 92 SC. Though the decisions relate to partial partition, which were recognized as valid under Section 171 of the Income Tax Act, it equally applies in the case of total partition of joint family property. Now, with effect from 1st January 1970, only total partition is recognized under Section 171. Now, coming to single Kopasana. Similarly, where there is only a single Kopasana and other members of the family are females not entitled to any share, such as wife, mother, unmarried sisters, unmarried daughters, who have right of maintenance. A family arrangement can be arrived at with those members by Karta, allotting to them specific property in settlement of their claim. For example, in a joint family between the mother and a son, it would be quite legitimate for the son to give one half property to the mother in lieu of her right of maintenance by way of family arrangement. CIT versus Narayan Das Badwa, 1980, Volume 123, ITR 281, Punjab and Haryana. Similarly, it would be open to Karta to allot property to the unmarried daughters or sisters in lieu of their claim of maintenance and marriage expenses by way of family settlement. Therefore, where partition cannot be effected for some reason or the other, it would be advantageous to allot the property under a family settlement. Now, coming to requisites for family settlement, requirements for family settlement. The requirements of a valid family settlement are: first one is existing or future disputes or differences between the members of the family in respect of their rights on the property. Second one is existing of claim or semblance of claim of the various members of the family on such property. Third one is resolving of the said claim by the family settlement arrived at between the members of the family, including the guardian of the minor involved. That prior to settlement, there should be some evidence of claim or counterclaim or differences or disputes between the members of the family on this issue, which will justify a family arrangement taking place. The best evidence of this would be litigation in a court or exchange of legal notices between parties and adjudication through arbitrator. But it is not absolutely essential. Pulia versus Narasimha, AIR 1966, SC 1836. Further, it may be also noted that in the case of non-Hindus also, family settlements can be arrived at between the members of the family. Now coming to non-Hindus and family settlement. It may also be noted that in the case of non-Hindus also, family settlements can be arrived at between the members of the family. If there are disputes whether the properties are individual property or joint family property, such a disputes can on filing suits and then arriving at some family arrangements be settled and properly transferred to other members, which will not attract gift tax or capital gain tax or invite registration. Of course, now after 1st April 1997, gift tax levy is abolished. Coming to individual properties. In the case of individual properties, whether in respect of Hindus or other communities, there can be a valid family settlement. The other family members can have a claim in the estate either on account of rights of maintenance or otherwise. And in settlement of such claim, a family arrangement can be arrived at which will be considered to be one for a valid consideration. And therefore, such a settlement will not fall within the ambit of Section 64 of the Income Tax Act 1961. Such a transaction is clearly with and for a valid consideration. Obli- Obligations regarding maintenance are to be found under the general law and specifically under the Hindu Adoption and Maintenance Act of 1956. If any settlement takes place in this connection, it will be for a valid and valuable consideration. It is also significant that in case of family settlement, the courts have gone so far as to hold that such family settlements do not amount to a trust. These observations are to be found in the decision of Supreme Court in Chandran Das versus Girja Nandini Devi, AIR 1966, SC 2323, and other cases referred to above. A particular instance of family settlement is found in the decision of Supreme Court in CWT versus Vijayava 117 ITR 734 SC, where there did not appear to be any legal claim of the son against the Maharani, but even then a promise by her to pay a certain amount to the son was held to be a valid liability created by her by way of family settlement, which was binding on the parties concerned. It may be at that time the line is thin between a gift and family settlement. A gift cannot masquerade as a family settlement, which has to be bona fide and preceded by some dispute or difference between the parties as regard their claim. It is not necessary that the claim should be legal and valid claim in order that there should be a valid family settlement. But nonetheless, there should be some differences or disputes in order that it should amount to a valid family settlement. This is all about family settlement. Now, what can be the procedure to avoid stamp duty? A family settlement arrangement be made over. The concerned parties to deliver possession of the property allotted and title deeds and records to the other. After few days, affidavits we recorded reciting therein the factum of settlement, date of settlement, property allotted, possession transferred, documents title handed over, and arrangement implemented and acted on. The parties may make necessary application for mutation respect of agriculture land for entry in the register of record title maintained by the MC or local authority. If the property stands let out, notice of attorney in favor of the respect be given, fresh rent date we got executed, and respect we issue proceed. Necessary modification may got made with appropriate tax department for land and building taxes, house tax, and to her taxes, electricity. But after some time, a memorandum or confirmation according the events may be executed for own satisfaction. It should not be in the present tense, but should be in the past tense. It should not create or confer any interest or right or title, but may acknowledge the factum of claim accepted and acted upon. If the family arrangement is not required to be registered, what is the evidentiary value of such family arrangements? Even if the family arrangement is not registered, it has evidentiary value. It is binding on persons who are party to it and who have taken any advantage under such family arrangements. A family arrangement being binding on the party to the arrangement clearly operates as an estoppel to preclude any of the parties who have taken advantage under the agreement from revoking or challenging the same. This was held in Kale versus Deputy Director of Consolidation, AIR 1976, Supreme Court 807. Even a family arrangement which was registrable but not registered can be used for a collateral purpose, namely for the purpose of showing the nature and character of possession of the party in pursuance of family settlement. This was also held in the same case, Kale versus Director of Consolidation, AIR 1976 SC 807. A family arrangement or settlement, even embodied in a compromise degree, is binding on all the parties to it. A consideration which is expectation that such a settlement will result in establishing or ensuring amity and goodwill amongst the nations, having passed by each of the disputants. These settlement consisting of recognition of rights asserted by each other cannot be permitted to be impeached thereafter. A party who has taken benefit under the transaction is not entitled to turn around and say that transaction was of a kind which the other party could not enter into and was therefore invalid. This was held in Charandas versus Grija Nandini Devi, AR 1966, 1966, Supreme Court 329. Now, another question, whether it is necessary that arrangement is bona fide and for consideration. Yes, if a family settlement or a family arrangement is found to be a bona fide voluntarily without coercion, under influence, misrepresentation, and stands acted upon. That is without under influence, under without misrepresentation. It deserves to be upheld and accepted by the courts, even if it involved release, relinquishment, or surrender or disposition, assignment, or transfer. Mm. For this, you have to refer to Srimati Vidyavati Devi Jati versus CDT 1988. So, briefly stated, so conflict of legal claims in present or in future is generally a condition for the validity of family arrangement. It is not necessary so. Even bona fide disputes, present or possible, which may not involve legal claim, will suffice. Members of the joint Hindu family may, to maintain peace and to bring about harmony in the family, enter into such a family arrangement. If such an arrangement is entered into bona fide and terms thereof are fair in the circumstances of the particular case, courts will more readily give consent to such an arrangement than to avoid it. This was held in Pullia versus Nasim AIR 1966 SC 1836. Now, can any property be allotted to female by family arrangement and quantum? Yes, any property can be allotted to a female in lieu of her right of maintenance, marriage, or to discharge any other obligation. No set formula is about the amount. It depends on the status of family and the claimants. No set formula can be made for fixing the amount of maintenance. It has, in very nature of things, to depend upon the facts and circumstances of each case. Some scope for leverage can, however, be always there. Court has to consider the status of the party, their respective need, capacity of the husband to pay, having regard to his reasonable expenses for his own maintenance. This was held in Shrimati Jaspreet Kaur, Saigal versus District Judge AIR 1997 SC. Now, is a family arrangement transfer under section 2 subclause 47 of the Act attracting liability to capital gain? No, it is not transfer and there is no liability to capital gain. Whether the concept of family arrangement can be extended to firms and companies. Family arrangement can be arrived at amongst individuals and not between companies. That's all. Thank you for watching. God bless you all. See you again.